You have the right to remain silent. Everything you say can, and will be used against you in a court of law. You have the right to an attorney during interrogation. If you cannot afford an attorney, one will be provided to you. Do you understand the rights I just recited to you? Phoenix, Arizona, March 11, 1963. Ernesto Miranda was arrested, due to the evidence of his involvement in the kidnap and rape of an 18-year-old woman after a lengthy interrogation process. He wrote and signed a confession in which he pleaded guilty. Despite specifically writing that the statements were made willingly, without any threats, and in full knowledge of his rights, he was never told of his right to have an attorney or to refuse to talk during interrogation. The Supreme Court invalidated Miranda's conviction, but the state of Arizona convicted him again, this time without the use of his confession. Despite the lack of this evidence, Miranda was convicted again based on the testimony of his wife. Miranda Rights were created in 1966 in the aftermath of the Miranda v. Arizona case. The Miranda warning's purpose is to protect the suspects from answering to self-accusatory questions against their will. This is protected by the Fifth Amendment of the Constitution, which protects individuals from being forced to provide incriminatory information about themselves. The violation of it will result in the evidence being invalid. For Miranda rights to be in effect, an individual must be under police custody, in other words, under arrest, and during an interrogation. It is important to know that evidence other than a testimony are protected by the Miranda rights. Other forms of evidence such as handwritten confessions, recordings and DNA samples can still be used against a suspect regardless of his or her awareness of the Miranda rights. With those rights in mind, do you wish to speak to us?